Welcome again, everyone. Welcome to Ask the Pros, Wills, Trust, and Your Estate Plan. I hope you're all ready to get into this. I give you Evantz.
Ladies and gentlemen, how are you guys today? I'm glad we play that kind of music because we want to make sure this is interactive. So I want to introduce the whole panel. My name is Evantz Saint-Gerard. I'm a real estate agent for about 10 years here at Keller Williams Realty Landmark. And I want to introduce Tushanna.
Hi, Evantz. I don't know where my video went.
Okay, Tushanna, tell them who you are.
My name is Tushanna.
Start your video, Tushanna.
I am trying to, Dean. I don't know why it's not going.
Tushanna, just tell them who you are.
Okay, my name is Tushanna Manram, and I am one of the best buyer's agent that you're going to ever work with. I am part of Team NWE.
All right, and then next we have Dean Graber.
And my name is Dean Graber. One of the leaders of Team NWE along with Evantz. I'm happy to be working with Tushanna and with Andrew here. And our goal today is just to help you understand everything that's going on pertaining to this topic at hand. Thank you.
And last but not least, we have Andrew Jaloza. Andrew, you're on mute.
That would be good if I take that over mute.
Yes.
Welcome, everybody. Thank you for coming this evening for a conversation about real estate and about estate planning. I am Andrew L. Jaloza, and I am the principal attorney at the Estate Planning and Elder Law Group. And you're in for a treat tonight because we're going to answer your questions about real estate and how it relates to estate planning. So sit down, buckle up, and be ready to enjoy.
All right, so a little bit of house cleaning. If you have any questions, there's the Q&A button on the bottom. Please put all your questions there. We will answer them. Myself and Shayna will be responding to them. We're going to be putting some stuff in the chat as well. So if you're looking through a computer, you can look at your chat and you can see some of the stuff that we'll be posting there. Our contact information will be put in there as well. So our first topic we're going to talk about is why is it essential to plan for the future when owning or buying real estate? So I'm going to give that to you, Andrew.
Thank you very much. Well, I think that when someone's going to buy their first home, especially, it's probably the largest asset that they've ever considering buying. It's you may have written some checks before in your life, but never like the ones you're going to write if you're going to buy a piece of property. And it's a good thing to be thinking about some of the things that may happen that may not be so nice. And that means making some plans for what happens if something happens to you, so that your property will go to whom you want, when you want, and how you want, if unfortunately something did happen to you. You also have to be concerned, I think, when, like estate planning is not just about dying, right? I mean, most people think that estate planning is all about what happens when I die and what's going to happen to my property. But really, it also is a lot of other laws, rules, and documents that can put you in control of those laws and rules that you need to think about. Like, for instance, when you start out, you're a young family, you buy a house, what would happen if the breadwinner all of a sudden died? First of all, we have to make sure who it goes to. And, by the laws and the rules of the state of New York, you may be surprised to find out that if he was married to his wife and the property was not jointly owned, that property wouldn't go directly to his wife. It would be split equally between his maybe minor children and his wife, which creates a whole other wave of issues having to deal with, who is going to represent the children and who is going to represent the wife. And the fact is that it was intended probably that the wife would own the whole property. So it would be a good idea to put together a will to say that if it happens that the husband, the breadwinner, if it's the wife, gets incapacitated, and they own the house in their own name. You have to have some documents, power of attorney, healthcare proxy, so that the survivor, the one who's not ill, would have the authority and ability to deal with that house and to make sure that the bills got paid and having life insurance. Another example of doing some estate planning, life insurance to pay that mortgage in the event that one of the breadwinner passes and you now have this mortgage. How is that mortgage going to get paid? So real estate and estate planning, especially when buying real estate, really does intersect. And there's many of those considerations to think about. Next
All right.
topic.
So the next topic is the benefits of having a will.
Well, like I said, have a will, not have a will. Both of them are a choice, right? You make that choice. Kind of like choosing to plan and choosing not to plan. How many times have you heard a failure to plan is a plan to fail, right? That's what happens in this situation as well. So there are two different ways things work. Say someone owns a house, they pass away, and they have no will. As I said before, it doesn't necessarily go to the person who you think it will go to, because what happens is a proceeding called administration must take place in the surrogate's court, and you need to go follow the laws and the rules of how the state will decide who gets gets your property. So for instance, it's a family tree that A will give half to children and half to the surviving spouse, as I explained before. But what about the situation when two people are living together for a very long time, buy the house together, and don't own it in a way that provides for a right of survivorship? So very, like we talked about before, where you like real estate and estate planning kind of intertwine. The other example is when you're buying the property, buying it and making sure that the title is properly done, so that if something happens to one of you, that the other will be the one to get the property, and then it stays in the family, stays with the survivor 100%. And that would be creating a joint tenancy with right of survivorship if you're not married, and joint tenants by the entirety if you are married. So that right of survivorship would go into effect automatically, and the property would pass to the survivor. If you don't do it that way, it turns out to be tenants in common, and then each one of the owner's heirs are entitled. So if the husband and wife don't own it by tenants by the entirety, or two partners who are not married own the property, when one dies, it does not go automatically to the other. If there is no will, then what will happen is that the deceased partner's property will go to whoever their heirs at law are. It could be, it could be out to second cousins. You may be partners with your deceased significant other's cousin if that happens. How do we avoid that? Have at least a will. A will is a document you create, you name an executor. The executor now is in charge of dealing with whatever property you own in your own name when you die, and now that executor must take that will, go to the surrogate's court, so you now have what's called a process called probate. Most people have heard of probate. Many people think that by doing a will, you avoid probate, but that's really not true. You do not avoid probate by doing a will. A will is really your ticket to go to probate. So important to think about them beforehand, important to have them in place. How many times have either of you seen a situation where it turns out to be a big surprise who's entitled to the property when someone dies because the papers aren't in order? I'm sure you guys see that all the time.
We see it. It's more common, unfortunately. Like you said earlier, when people don't plan, you do see this a lot. This is one of the purposes why we wanted to put this webinar together, so we can, have people avoid this. It's very easy to fix these issues if you plan.
I just wanted to comment on that for a second. So, like with real estate, we need a clear. It's best for you. It's best for everybody involved if we have a clear highway to travel on. And since we know what's going to be coming up on the highway in most events, we can get our job done. We can help you get what you want in the time that you guys want at the best price, whether you're a buyer at the best price or whether you're a seller at the best price, for that side of the table. If the lanes are clear so that we can move forward. And since we know that this is going to be coming up, that's why planning is important. Tushanna, what's your input on that? You're muted. Yeah.
I have a friend on the phone that's texting me right now. Her mom recently died and she was at loss. She didn't know anything. If her mom had insurance, if her mom had a will. So these are things that it's not you say that it's not going to happen to me. You do not know what tomorrow holds. So it's something that you really need to consider. It can happen to anybody.
Yeah, it's a really scary proposition. I mean, the most important thing about a real estate transaction is knowing who owns the house, right? Who's going to be able to sell the house? People live in I'll tell you one story. I have a house right now in Brooklyn that the last deed of record is 1908. There are 36 heirs of the 7 families that were part of this family, all of them living now, 36 different heirs living. Only 3 of the 7 lines are active, and it is a nightmare trying to settle the title so that this family can sell the house. And how would it have been avoided? Some kind of estate planning. See, most people think that you have to have a gigantic estate, like you have to have a big mansion and a big lawn to do estate planning, right? I don't have an estate. Why do I need to do estate planning? I don't have a lot of money. Why would I do estate planning? Estate planning really is for everybody. Once you turn 18, anybody in this world is now an adult and no one else really has any control over them. Simple estate planning documents like a power of attorney for your 18-year-old kid going to college is a really important thing, because if something happens to them while they're in school at their 20, 21, you cannot do anything for them. You're not legally authorized to do anything for your child, notwithstanding the fact that you're blood relatives. So having a power of attorney for anybody over 18 would probably be a smart idea, as well as the healthcare proxy, so you can call up the clinic and find out what's going on with them. Also, putting these documents in place, you do have an estate. If you have a house, you have an estate, because what you have is an asset. That asset does not pass to your family members automatically. If you don't do some planning, then the government will be involved in your family's life, and in some way the government's going to make the decisions for you.
And I wanted to say something. I was just thinking about something when you mentioned, even if you're 18 years old, this is for you. I was thinking back, when people are 20 and 25, 18, 20, 25 years old, they don't think related to even just life insurance. They don't relate it. Why do I need life insurance? I'm just 20 years old. And then you get married and you become 30 and you become 40 years old and you start thinking, maybe I should get life insurance one day. And then you become 55 and 60 years old and geez, it's too expensive now. It's too late. It's just like I should have bought the policy when I was 20, because it would just be more beneficial at the end. So that's all. It's just an analogy, if that makes stuff simple, with why to start early.
Look, let's face it, basically, this is a difficult subject to have, especially with family members. You have to have these difficult conversations. Have them now, or you're going to have a difficult situation later on. That's one of the things we want to prevent. If there's anything else, basically, we're going to go on to the next topic, or is there anything else you want to add to this one?
I'm good on this topic. Anybody else have any questions?
Yeah, feel free. We do have a question in the Q&A. What if it's not a house and it's an apartment in a NYCHA building?
Well, there are some types of real estate that are different, right? Like a NYCHA building is, if it's not, there are some things like Mitchell-Lama apartments. There are some like NYCHA apartments, subsidized housing. Those are not really assets, but because you can't pass it on to someone. It's not like you can pass on a house that you have in a NYCHA building. It's not like you can just pass on your Mitchell-Lama co-op to anybody you want. There are rules around that because the government is subsidizing that building, that created that building, and it was meant for a certain type of person who has a certain level of income. So you can't pass that on, but what about the rest of your assets that you have? If you have IRAs, if you have bank accounts, you want to make sure that your plan is sound so that it goes to who you want, right? So even like most people have 2 things. If they've worked, say, for any length of time, most people at this point have, some place to live, whether they own it or not, and some retirement account. If they work for, especially if they work for, city or state or federal government. And now you have these are assets. These are assets that you want to make sure are going to go to whom you want it to go to. Because what's the point of all of the working, the hard work, the accumulating things? We want to make sure it goes to the right people, right? We can't take it with us. And if you don't do the planning, it doesn't necessarily go to the person you want it to. It may not seem like a lot when you compare yourself to Elon Musk, nobody has anything, right? But if you compare yourself to where you came from where you started, you certainly have a lot more than when you started out. And you probably have someone you want to pass it on to, that generational wealth that you want to pass it to. That your family house is a huge asset. And it's a huge asset and a huge advantage to your children and your relatives when you pass it on to them.
All right, Andrew, we got quite a few questions coming in, so I'm trying my best to read all of these. So excuse me, guys. How is the house titled when moved into a trust? Someone told me it was titled under trust, and someone else told me it was titled under the trustee, and it's needed to retitle by the successor trustee after I pass away.
Okay. We can talk about that. Well, we can hold on to it for a couple of minutes until we talk about the difference between wills and trusts, and then we'll explain the titling.
All right.
You want to go on to the next question?
The next question is basically, it kind of ties into everything. Why is estate planning important for everyone, not just the wealthy?
Well, again, so estate planning is not just what happens when you die. Let's try to change that first, that idea about it. Like I said, a power of attorney is an important document because, as I said before, if you don't have a will, then the government's rules will apply. If you don't have a power of attorney and something happens to you suddenly, or if you're watching as your grandparent or your parents' mental health declines and you don't get a power of attorney done, what happens is when the capacity is gone, you now cannot use it. You cannot get a power of attorney, and you need to go get a guardianship appointment, right? I don't know if anybody here on this call today has had a guardianship appointment in their life, anybody they know. It's a very invasive procedure. It's very expensive. It's time consuming. You're now putting the control of you, if you're the person who the guardianship is for, in the hands of others, maybe not even someone you know. So how do you avoid that? By doing some planning. It doesn't matter how much money you have, but if you have any money or property in your own name, it makes sense to get, at the very least, a simple basic plan. So this way, if something happens while you're alive, you get injured, ill, or very sick, mentally unfit, you will have plans in place for who will take over for you. So you can keep control of the process and who's going to do things for you. If you die, you have to make a choice. Do I want to use a will, or do I want to make sure I use a different process so that we can avoid probate? Let me talk quickly for a moment, if you will, about what probate is. It's a legal process. It takes place in the court. Where do people go to fight? They go to court to fight because you can't go out in the street. You have to go to the court. You don't go into the gladiator pit. You don't get your gladiator and their gladiator and duke it out. You go into court. So what happens when families and money mix together and then you put court in the middle of them? They're fighting, right? That's what happens most of the time. How many times have you heard about that family? Everybody gets along. Don't worry, we all agree. And then some money or property comes in because someone passed away. And what's to happen? Those people who say we all agree are the first ones fighting. So how do you avoid your family having to do that? Well, rather than using a will to put your estate plan together and pass things on when you died, you can do a trust. And a trust is an agreement that you create with three parties: grantor, the person who owns it; trustee, the person who manages the property; and beneficiaries, who's entitled to it. What a trust really is, it's like a little red wagon. A little red wagon. What is this guy talking about? He's talking about a child's toy? No, I'm talking about the thing I use when I go to the beach. That big little red wagon that you drag along behind you. So this is why I talk about the little red wagon, because it really helps to explain estate planning and what a trust is on a very simple level. If you think of all of your assets as little gift wrap boxes, right? And you're carrying your boxes, you start out in this life, you have no boxes. Then you get some baseball cards, and those are your boxes. And then you get all kinds of other stuff. And before you know it, your arms are full with all different sized boxes, because all of your property and stuff that you accumulate over your life. You're walking through your life, you're carrying them in your arms, you fall down, injured, ill, or worse, dead. What happens? You fall down, of course, and what happens to those boxes when you hit the ground? They go all over the place. Now, who's going to pick up those boxes? If you're ill and you have a power of attorney in place, then your agent will pick up those boxes, straighten them out, put their arm around you, and help you with your boxes. If you are dead and you have a will, then your executor will get those boxes, but they can't even bend down to pick up the boxes until the will is submitted to probate and the court says it's okay to pick up the boxes. That could take 7 months to a year and a half, 2.5, 3.5 years, sometimes in probate, before the assets get distributed out, because if there's fighting, if there's problems, if you can't get everybody, you can't find someone, it's a whole gigantic issue, and all of it controlled by the state's rules running your life. So rather than carrying all these boxes, you take them, you pile them neatly in your little red wagon. You grab the handle and off you go. You have all your stuff in there, you put stuff in, you take stuff out, you're in complete control of your wagon, and that is what a trust is. It's kind of like a little red wagon. You fall down injured or ill or dead, the boxes stay neatly in that wagon. You're going to hit the ground because you're injured, ill, or dead, but your your assets will be perfectly situated in there, and attached to the handle of your wagon will be this family rule book, that trust agreement, which will say what's going to happen. You appoint who's going to take over if you're sick. You tell them the rules that you want them to follow. You also say what happens if I die. You can do all kinds of planning for that. And when you transfer title to your trust and put it into the name of the trustee as trustee of your trust owns it. Your trustee does not own it. You, generally speaking, will be your own trustee, especially for this little red wagon. It would be like a revocable living trust. You create it because it's living, right? It's a living trust. You create it while you're alive, and you're now in control of everything. You can do anything you want with it. Put things in, take things out, put your houses in. You now own this thing through your trust now owns your house. You die, there is no probate. You're sick, your successor trustee will take over and help you plan to put it away and get protection for it if necessary, to protect you against what the costs of what happens when you get sick. So it's a great thing. A trust is a different type of instrument than a will, and will allow your family to simply pass things on in the future. There's no waiting for the court, there's no waiting for anything. All the rules are contained in there. You made all the rules. The trustee has to follow it. During lifetime, and you're okay, you're the trustee. Pass on that right and rules to someone else to do it for you after. So we discussed what a will is, and we talked what a trust is, and we talked about how to avoid probate by using a trust, because when you put the property in the trust, it's not in your own name anymore and will not have to be probated. It will go according to the rules of the trust. Everybody understand that?
I think so.
I
We got
have a question. Could a trustee overrule the person who's alive that puts something in a trust?
No, the trustee has to follow the instructions of the grantor. Grantor still is in that kind of trust. What we're talking about is a revocable living trust as compared to doing a will. The revocable living trust plan, and anytime there's a trust, the rules of the trustee are clearly set out in that trust, and it's also statutes and rules of the state of New York, and every other state has their own trust rules as well about what the duties of the trustee and what they have to do. Their job is to technically protect the integrity of the trust, protect the trust for the beneficiaries, and follow the rules of the grantor.
Okay.
All right, so we have a lot of questions coming in. You guys want me to read the questions first, or you want to go back to the material? What do you want?
We can
Knock out some questions.
All right, so number one question, this was from Carrie Ann. Will this be, yes, this recording, and this is being recorded, so everybody who registered will get a copy of the seminar. And I'm trying to see what her other question was. For some reason, all right, so if I am the only heir to my father and he doesn't have a will, would that cause problems? And that's from Carrie Ann.
I'm sorry?
She's the only heir to her father and he doesn't have a will. Would that cause problems?
No, but most likely it's still gonna have to go through probate, even if she's the only heir. So there's another issue when you get to deal with real estate and how it intersects with estate planning, is that, you know, you also have a title company that's involved. It used to be that title companies would pass on properties as sole heirs. Like you have all the heirs, they technically have the right, legally have the right to sell the property or transfer the property, right? It's different from the legal right to do that and how it works when you have to deal with a title insurance company that's going to insure the title of the person who's buying it. Most of the time in these days, the title company is not going to agree to allow the passage by sole heir and will require it will require the property to go through the probate procedure, because this way the surrogate court determines who is the sole heir, who's entitled to it. It takes away the liability of the title insurance company. So what you can do is you can do some estate planning. You can do simple estate planning. What you do is you do a life estate deed. You do a deed transferring the property to your child and holding back a life estate, which will pass automatically without going through probate. That will pass, that's one way to do it. But passing that property to your child also puts your house in your child's hands, because now they own most of it and you only own the life estate. If you want to paint it, you want to borrow money, you have to get your child's permission. If your child runs over somebody with their car and badly injures them, now that lawsuit is against your house because it's in your child's name. If your child gets divorced, their spouse may get it. You may be living in your daughter or son-in-law's house. So there's a downside to doing that. Put it into a trust. You don't have to worry about probate. If you don't want to do that, there is a way. Transfer away at least part of the property during your lifetime, and you can succeed in avoiding probate completely.
Okay, the next question we have coming up, we have quite a few questions.
Somebody raised their hand.
Yes, hold on. Gregory, I'm gonna allow you to talk, so tell us what your question is. Gregory, what's your question? Gregory, you're unmuted, you can speak. What's your question?
Can you hear me now?
Yes, we can hear you. What's your question?
Okay, fantastic. How can my elderly mother qualify for Medicaid to pay for long-term care? Right now, she doesn't, and she owns a co-op.
Okay.
That's a great question. Well, so that's another reason trust planning or planning in advance is important, right? Because Medicaid has look-back periods. There's a government program called Medicaid. That's not Medicare. Medicare does not cover long-term care issues. Medicaid does. You have to qualify for that. If you're a single person with more than $17,000 of assets, including your home, you don't qualify. If you're a married couple with more than $140,000 of assets between you, you don't qualify. There are exemptions for your house when you're married that don't exist when you're single. But both parties, whether single or married, doing pre-planning and planning to protect against Medicaid is an important thing to do. What we do is we create a Medicaid trust. And what that trust will do is it will, subject to the look-back period, will shield your assets from being countable resources if you need to get Medicaid. If you don't have it protected, they will give you Medicaid and they will put a lien against your property and collect back what they gave you before your children get anything from your estate. So this Medicaid trust, by creating it early enough, will allow you to avoid having concern about it being subject to long-term care, and will protect it so it will get you qualified for Medicaid. Long enough is the question. When are you going to get sick? Nobody knows. There is a 5-year look back for Medicaid used in a nursing home. There is about to be 2.5-year look back for when they come into your house or you go into an assisted living under the community Medicaid program. Either way, you cannot plan away the look back period, but what you can do is prepare for it by starting early. So the clock starts ticking when you transfer your property to the Medicaid trust, and that eventually you're through this place where no matter how far they look back, that transfer into your trust doesn't count anymore and your property is protected. So to answer his question, plan early, use the techniques that we have to plan for you, and you can protect your house and other assets against long-term care problems.
Okay, we have Gregory, I hope that answered all your questions. We have a question from Bill. We'll allow you to talk. Bill, what's your question? Unmute yourself.
Okay. Andrew, when is that 2.5-year look back period coming into effect?
A great question. I wish I knew that, like I know the number for the $1 and $2 billion and a half dollar lotto. See, the thing is it has not been, so April 2020, New York government passed a 2.5-year look back for community Medicaid. Like I said, community Medicaid is people coming into your house to help take care of you, or you going into an assisted living facility, and provides other things as well. Up until now, there really is no look back. We call it a 30-day look back period because you have to show there are no transfers that were done in order to get yourself qualified right before you're applying. So in April of 2020, they passed this 2.5-year look back that was going to be implemented as of October 1, 2020. And every month thereafter, they were going to add another month until there was a full 30-month look back, or 2.5 years. So that's what we're facing. But something else happened in the beginning of 2020. That's called the COVID pandemic. And the federal government passed this Public Health Emergency Act, which is still in effect. It has not been lifted yet. And how federal government and state government interact with respect to Medicaid is the public health emergency prohibits the states from implementing any laws that are more restrictive than the ones that were in existence before January 1, 2020. That's what's holding up the implementation of the look back period. As soon as the healthcare emergency is lifted, approximately 180 days later, because it can't go into effect until the quarter after the quarter in which the look back period is lifted, and they're supposed to give us a 60-day notice before they lift the public health emergency. So as of October, they didn't lift the health emergency. They cannot implement it in January, and they may, if they do it before January 1, may be able to implement it in April 2023. But, I have to say that most of the experts and the people who really have the finger on the pulse of this think that it will be probably implemented sometime toward the end of 2023 at the earliest. Right now is an opportunity for people, though. If you do have a house and you want to protect it, it is a good time to do that planning, because right now there is no transfer penalty for transferring with respect to community Medicaid. And they say that it won't go into effect against people who get qualified before the implementation begins. Does that answer your question, Bill?
Quite well. Thank you very much.
Thank you.
Thank you, Bill. All right, so we're gonna go back to, we have quite a few questions, but let's jump back into the syllabus. We'll run through this. All right, first question, Dean, this is for you. How do you sell a home during the probate process?
How do we sell a home during the for me?
Yeah, well, I'm going to give this to you and Andrew, both of you. You guys can collaborate on this one.
All right, from our perspective, if it's during the probate process, we do the same thing. We just look for, if we're selling a home, we just look for a buyer that has time on their side. By that, I mean someone without a deadline, someone that's not selling a house as well, somebody that's currently living with family, renting maybe on a month-to-month lease. We're open and honest with the buyer as to what the seller's circumstances are. And that's about it. It's the same process. It's just going to make the pool of buyers a little bit smaller, only because it's the buyers that have time on their side and can be patient.
Yeah, I think that the other side of it is that often what we do is we enter into contracts with the proposed executor,
Exactly,
with the proposed administrator. But this way, at least people, are sort of together doing a contract, considering their funding and whatever they have to do to get their things together. And then when the probate process is complete, the executor is ready to then sell, and generally the mortgages, whatever things you have to do to conditions satisfied to get the mortgages done.
All right, so the next question is, who has the legal right to sell the home? So that's to all the panelists.
That's a wide question.
I know.
I mean, that's like saying, how long is a rope? No, but the truth is this. So who has the legal right to sell the home? It really will depend. The person whose name is on the deed, definitely, right?
That's the
When
facility.
the person on the deed dies, the question is, did he have a will? Did he not have a will? Was there a life estate? There's a whole bunch of different things that happen, right? And it depends upon what you do during your lifetime about how easy and smooth or more difficult it is to sell that home. So do planning. If you're planning, you use a trust, then you put in control whom you want to, they'll be empowered to sell the home, right? And then without having to go to court or do anything like that. It helps to avoid the fighting because you don't, you set down the rules. If it's your kids, of course, kids never fight, right? They never fight with each other.
No, not at all.
Not
Me and
at
my
all.
brothers and sisters, we all get along.
Always.
We sing
Everybody
Kumbaya
gets
every
along.
day.
And then there's this thing that's called money. You throw it in the middle, and all of a sudden it's kind of like a rugby match. Everybody's jumping in, and there's a scrum, and everybody knows what mom and dad want. Everybody said this is what was supposed to happen, that was supposed to happen. Or you have that cousin, second cousin, who's living in the house. He says, this is my house because I'm living here. Yeah, there's all kinds of crazy stuff that happens. Avoid it by thinking about when you're purchasing to put things in place. Because when you do that, then you have peace of mind. You have peace of mind knowing that if something happens to you, whatever it is, you kind of control the situation by putting people you can trust in control and letting them follow your rules by making sure that there's rules for them to follow.
All right, so the next topic is, what is the purpose of a living will? You kind of addressed that earlier, but I just wanted you to hit that on the head one more time.
A living will is something different than a last will and testament, right? So people think of that people usually confuse the two things. A living will is more really like an advance directive. What you're doing is you're saying to whomever is going to help take care of you, you name the healthcare proxy in a different document, and you use a living will to amplify what your instructions are about what you want to happen to you. If you're in a coma, don't resuscitate me. If you are in a coma, do whatever is necessary to get me back in, do it for a certain number of days. You put different rules in so that you can explain in your own words and with some legal authority what it is you want. What we do, we call have a thing called the personal care plan. We ask what you like to watch on television. What do you like? You want to go to the movies? Books do you like to read? This way, when someone is helping take care of you, they have a really good idea of who you are and what your likes and dislikes are. Can you imagine if you liked Fox News or you liked MSNBC and someone's putting you in front of the other and you can't change the channel? That wouldn't be good, right? So the point is how we avoid that is you tell somebody in your papers, this is what I like. I want to watch this, not that. So you get to make those choices in a living will while you can. Because then there comes a time that you can't, and now you're just subject to everybody guessing. And everybody, like I said, kids never fight until they're trying to both say, this is what mom wanted. She liked this, not that.
All right, so the next topic, I see a couple of questions that we have in the Q&A. This will probably answer those questions. What are the rights of survivorship?
So rights of survivorship are sort of a estate planning thing, right? So that you own property when more than one person owns a piece of property, whether it's real estate, other assets, right? A right of survivorship means that when you die, if two people own the property, when you die, the one who died is now dead. Their interest at the moment they died is now belongs to the survivor, okay? So now they own it 100%. If you wanted that property to be split a few people, you have to be careful because you have to know that survivorship will cut that off. When you put rights of survivorship, automatically by operation of law, upon the death of the first person, it's going to be wholly in the name of the second person. What if they're in a nursing home? Big problem, right? Or what if they have debts out the window? And now the other person who's attached, who is no longer there, they own 100% of the property, and someone who has sued them and has a judgment is waiting to get paid, that all goes there. Having rights of survivorship is a great thing. It helps you avoid probate. And that's what your financial advisor will say most of the time. But what they're not also considering is that really it makes it locked in, and that thing that's locking it in may cause unnecessary harm by the unintentional consequences that happen. It may be better to do different types of planning for it so that this way, when the property passes, it's passed in a way that there's some protection or there's some rules around it. Like when you have a kid that you give $1 to, he spends 10, or you have a child who has an addiction problem of some sort. You give them money or property outright, it's a big problem. And if you are joint owners with right of survivorship, that's what's going to happen. They're going to get it. They do whatever they want with it. How you protect against that is use planning, estate planning, to change that and make it so that you can put plans in place for the future.
All right, so the next couple of topics, I want to do a rapid fire because we have a lot of questions. I want to make sure we answer
let's get
all
to
of
the
them.
questions.
So let's do the common uses of trust and how do I start a trust. So I'll put those two together.
So common uses for the trust are, real estate is one of the most common things that we use to either for asset protection. You have a risky business, you are concerned about long-term care, you take your house, you put it into the trust. Once you do it, you're protected against anything that may happen in the future, subject only to the look-back period. And once it's through the look-back period, now you're protected against everything. Everything means everything. Like, the IRS will not be able to get it if it's properly drawn and you create these trusts. And also, this is the same thing of providing protection in the future. What do we use trust for? When we're giving property to our kids and we want to make sure there's some rules around it, you have to use a trust. Whether you use a will to give it to them or a trust to give it to them, you need to create something that property is going to go into that you can create rules around. Because once you give somebody something, it's theirs. They can do anything they want with, including stupid things, right? So sometimes you have to protect your children from themselves, or you have to protect them from the potential divorce they're going to have. Or you got to protect them against what the stupidity they did beforehand, like owe a bunch of money to the IRS or something, and now there's a lien waiting for them. You put money into their ID, their social security number. Guess who's waiting? The IRS. That using trust allows you to do planning. It also allows you to simplify how you give it and who you give it to by taking the courts and the states and their rules and their control out of your life and putting it back into your life. So also used to do Medicaid planning, right? So lots of different reasons we use trust. Avoiding estate tax is another reason why we use it. Because if you have a lot of money, and I mean a lot, because for federal purposes, it's almost $13 million a person, or $26 million in 2023, and about $6.5 million in New York State. If you need to have a lot of money, but when you are subject to estate tax, it costs a lot of money out of your estate. And planning for that is also important, using the proper trust for that. How do you start a trust? I believe that you should come to somebody who knows what they're doing and help you do it. You can go on LegalZoom. I can tell you that there's several really crazy stories around people who went to LegalZoom or something like that. But if you go to an attorney who knows what they're doing, you can be assured that you're going to have the best possible outcome, I think. And if they don't, they have insurance to cover the loss if that's what happens, right? I think it's important to use good advice and go to an expert to deal with everything. Like going to buy and sell your house, who are you going to go to? You're going to go to Dean, you're going to go to Evantz, you're going to go to Tushanna, because they know what they're doing. You have the confidence because so many people have praised how well they did what they did, and that's why you go to them. So you come to someone like us when you need to do your estate planning and have a trust and a plan. It's not just the document, right? It's the planning around it. It's not just Evantz and Dean have been doing this for a long time, but the processes they've created, the way they deal with people, how it works, creates a much better process for the buyer or the seller, who is ever there, and makes more likely that the deal is going to work its way through with the least amount of problems. Similar to us, come to an expert. That's what I say.
All right. The next question would be, what happens if I fail to assign assets or fund the trust? I think you kind of touched upon that.
Then there's no point in creating a trust, is there? I mean, I can't tell you how many times people come. They come with the best one was they came with two beautiful ornate wooden boxes, gold handles, or like engravings on the side. I opened it up. Oh, there's these beautiful bound books, and there's not a single thing in the trust. Not a single thing. They paid $15,000, $20,000 for their trust, and no one ever put anything into it. The only way the trust works, it must be funded. You must make the trust the owner of the property, or else the trustee has no power to control it or deal with it or manage it. So yes, you must put things into your trust. Funding is essential. In my office, we don't give you your trust until it's funded. We make sure that everything is funded in it.
All right, and our next and last topic, we're going to jump right into the questions after this. How are assets divided once a loved one passes away?
Another open-ended question, because it depends. I mean, assets will be passed according to the rules you create if you create rules, right? If you take the time to make a plan. If everything is what quote unquote simple, I mean, you have one child and one married couple, one child, one dies, it's, if you don't have any plans, it's splitting between the, it's splitting between the child and the parent. You want it to all go to the parent, you still need to make a plan. Either make it joint tenancy with the right of survivorship, that's a plan. Either or create a will or create a trust to pass it on and put or the planning around it, that's a plan. So how your assets will pass to your loved ones will depend on whether or not you're making a plan and what that plan says.
All right, we're pressed for time, but I'm going to try and do these rapid fire. All the panelists can speak and answer these questions. We're going to talk about life insurance. Singles who do not plan to get married, should they buy life insurance, and what are the benefits?
You want to have something in case you pass away. You want to invest in something and have some money to take out of it tax-free. There are reasons why you want to buy life insurance, but this is really, I mean, it's not really the subject of this conversation, but there are definite reasons why even a single person would buy it.
All right, next one is if two siblings own a home, one passes away, does the other get the other person's share?
Not if they own it jointly with a right of survivorship.
Yeah, depends how the title is held.
Okay.
Yeah.
And
So something with that as far as planning, if that's a possibility going into it, you should look, you should make sure that you set up the title, the deed, the proper way, I mean, up front.
Exactly.
all right, so this one is if you have set beneficiaries on your IRA, a will isn't needed for that, right?
That's correct. However, if you have an IRA and you pass it to someone other than your spouse, there's no protection for that. So if you give it to your kid directly and they have a judgment against them, then that money is subject to their judgment creditors, the bankruptcy court, etc. If you use a trust to do some planning for that, whether it's in your will or set up a separate trust that you create, you will then be able to provide protection for that IRA. So passing on $1 million IRA to someone who has $500,000 in debts is not a good idea.
All right. If you have already life insurance and you don't think you need it, what can you do if it already, I gotta make this bigger so I can see. Sorry, I need glasses.
It already have cash value.
Yeah.
You can cash in the life insurance policy. You can. That's what the cash value means. You've invested in it. There's something there. What the good news about it is and the strategy is you're investing into something that you can take the money out and not have to pay any taxes on it. This is accumulated money. Insurance is sort of a tax-free type of investment as well.
All right, Lily wants to know if you do long-term care, and does that make sense to buy at 60?
Well, it depends. I mean, insurance of every type is sort of a bet, right? You're betting X amount of dollars to get X plus sometime in the future. In this case, you're seeking to get something for yourself, which is long-term care coverage. It costs $15,000 to $18,000 to go into a nursing home now. That's what per month. It's a per month fee. So
say that number one more time. The number
between $15,000 to $18,000 per month to go into a nursing home. The average nursing home in Queens at a decent nursing home is $15,000 to $18,000. In Manhattan, it's even more expensive. It's closer to $20,000. In Long Island, it's somewhere between $17,000 and $20,000. That's reality. So long-term care insurance is not a bad thing to have. If you don't have long-term care insurance, or if you do have long-term care insurance, it's still a good idea to do planning because long-term care insurance only usually lasts nowadays for a certain amount of time and for a certain dollar amount. So no matter what, it's good to have, but it's not the answer to everything usually.
I think we might have answered this question, but I'll read it again. What trust do I need for my elderly parents to protect their assets, and how can I get them to qualify for Medicaid for when they need long-term care?
A Medicaid trust requires that it is irrevocable and that the principal is not available for the person who's creating the trust. So you need an irrevocable trust. So you need specific rules. There has to be things that are in there that really make sense to go to a professional who is experienced to do that, because Medicaid is a very technical thing.
All right, how hard is it to create a trust, and is it a high cost to manage?
How hard is it is a very difficult thing to judge what you mean. Me, it's very easy. I do it every day. I create trust every day. I don't know if Shana could do a trust by herself, but at this point she probably can because she works here with me. I think that Tushanna will have a problem making a trust. It's probably very hard for her to create a trust. Is it high cost to manage? No, it's not really high cost to manage at all. The good news about it is it really is. It's almost like an investment, especially if you're doing an asset protection trust to protect against things going bad or Medicaid. It's really it's like an investment, because 70% of all people who turn 65 need long-term care. You have a 70% chance that this trust is going to create a better situation for you than if you don't do it.
All right. I was just going to say, in general, each person's situation is going to be completely different.
Absolutely.
The answer I'm going to always say is always seeking a professional to reach out and answer your individual questions. All right. Does a co-op classify as a limited profit housing company affect one's ability to create a revocable or irrevocable trust to protect my assets?
Well, a co-op period is a difficult thing to deal with because you always have to get someone else's approval. So a co-op, that's the form of living you choose, but that really has a whole bunch of rules. You're not making them, and it's up to the co-op to say whether you can actually transfer it into a trust or not. A limited profitability thing like a Mitchell-Lama is nearly impossible. They don't really agree to allow you to do it. Without them agreeing to transfer the shares and making your trust the owner, you can't fund it into a trust. So I would say, although it was getting to be that more and more places were agreeing to allow co-ops to be transferred in, it is a difficult process. It is expensive. It's worth it if you can do it, but co-ops are a difficult thing to deal with.
All right, we have someone that's asking, will there be a transfer penalty in the future?
Yes, there already is a transfer penalty for nursing homes. At 5-year look-back period, the transfer penalty is the same for both. Every $13,000 you transfer away creates 1 month's penalty. You may qualify for Medicaid, but they're not paying you anything until you go through that period, that look-back, that penalty period.
All right. What other documents should be put in place to protect not only for death, but in case of incapacitation?
Yeah, healthcare proxy, power of attorney. Depending upon how old you are and what your life looks like, you're going to need a different one when you're older. You need an elder law type of power of attorney to make sure that your agent has the power they need to either, get you the help in any way they can to protect your interests from long-term care and do what you need to do. It's a lot different than when you're 25 years old and you're worried just in case you get hit by a truck that somebody's going to be able to help you. You don't need them to be able to do gift transfers and things like that. You want them to be able to be there to help you.
All right. So Maria has a question. If it's an income producing property, can it be transferred into a trust?
You can, and you can also reserve the right to income if you are making it a Medicaid or an irrevocable trust. But if you're making it a revocable trust, in other words, that little red wagon, you can do anything you want. Take all the income to yourself. There's no limits. You can change it, revoke it at any time, amend it any way you want. So yeah, it's a very flexible thing. It's 7:01.
Yeah. Well, I'm going to wrap up some of these questions. I'll make them quick. I know you have to go. So how can somebody get access to a deed to a property in a name if the name is on it and the other party has deceased? So Dean, you want to answer?
How can one get access to the deed on property that their name is on it, the other property? Well,
that's public records.
Yeah, public records, you can get that information. Or better yet, just reach out to a realtor. They should be able to pull that information for you.
To just get access to the deed, absolutely.
You don't need permission for that.
So. Yeah, so how is the state specific for a trust if you move?
Well, for the most part, I would say that because of the full faith and credit laws of the United States and how states interact with each other, a properly drawn trust will work everywhere in this country. There are some nuances to Medicaid. Medicaid is a state-specific thing, so if it's a Medicaid trust, it will work. How it's applied is going to be the answer. So your documents, when prepared here in New York, if properly prepared, will continue to work even though you've moved somewhere else. It makes sense when you get there and you live there for a while to seek out an estate planning attorney in that state to make sure that everything you have is exactly the way that you want them.
All right, folks, we have reached the end of our time. We do have some questions left over. I just put in the chat our contact information, so I'm going to leave that open for a while. Please copy that. Just hit the copy and paste and save it. You can go to our individual links for the questions that you have regarding estate planning, wills, trust, and reach out to Andrew's team. Their information's in the chat. For anything real estate related, you have our contact information. You have our links to our website. If you click on each link, excuse me, I'm learning English.
Yes, if you click on a link.
If you click on a link, basically you'll have our information you can download straight to your phone. On my screen, depending if you're watching this on the computer, you can scan this with your phone and it'll go straight to my contact information goes straight to your phone. Sorry we couldn't answer every question, but that's the purpose of these videos, is to answer as many questions as possible with the time that we have. And if you have any other questions, the questions we couldn't answer right now, feel free to reach out to us. Again, our information's in the chat, and you will be getting a copy of this whole seminar again via email. So if you have any other questions that we didn't cover, reach out to us. We'll answer them the best we can. I'm going to sign off. I'm going to let the panelists, if any last words of encouragement for our viewers right now. So
I just want to say thank you for everyone being here, everyone that's hosting this, and all the attendees. And we're always here for you. Any questions that you have, that's why we do this. We make our information available. If you reach out to us, we'll be sure to reach right back out to you.
Education is very important. Most people don't understand the type of things that we talk about. People don't understand the ramifications. We're here to make it simple for you. Come to one of our workshops. We give away a lot of free information. Our website has a lot of information as well. We're always here to serve. We love working with Evan and Dean, and now with Tushanna. And it's really important to choose the right people. The right people are very important. And Team NWE is really the right people.
Nice.
All right, Shana.
You know me, I like to tell people to ask the professional. Don't listen to your auntie or your uncle or your neighbor. Ask the professionals.
Mr. Graber.
I'm going to just second that also. Like I said a minute ago, we're here to help you any way that we possibly can. And we'll try to have some good vision going forward for you. Just share with us what your concerns are and what your questions are, and we'll be sure to do the best to resolve them for you.
All right. So again, email will be sent out later on. It's going to have all our contact information in the email. If you have any questions, the purpose of these videos is to educate you guys. If you have any questions, well, you know, a lot of people, this is a tough subject to talk about. That's the purpose of these videos, to open the conversation, start the dialogue. You have us as your professional resources. Reach out to us. Whatever questions you have, we're here to help you. And that's pretty much it. I'm going to leave it to Shana. How you want to end this?
All right. Well, first, thank you all so much. Your expertise is deeply appreciated. That was so informative. I learned a lot myself.
Me too.
So that goes to show everyone, you can still learn no matter how long you've been doing this. So please, 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 thank you for joining us. Join us again. Contact our offices. Thank you to the panelists for providing us another amazing Ask the Pros. And everyone, I hope you have a great evening.